Can a bank close your account for no reason? Imagine waking up one morning, opening your banking app, and seeing a message that stops you cold. Your account has been closed. No warning. No explanation. Just gone. And you have bills due today. This actually happens to people every single day across the United States. And the scary part? It is completely legal? Welcome to Know the Law. I'm going to walk you through everything you need to know about bank account closures, why they happen, what rights you actually have, what the bank is required to do, and what you should do if it ever happens to you. Because knowing this information ahead of time could save you from a serious financial nightmare. Let's start with the big question. Can a bank close your account without your permission and without telling you why? The answer is yes. Absolutely yes. Banks and credit unions in the United States have the legal right to close a customer's account at their discretion. They do not need your permission. They do not need to state a reason. Federal law does not require them to explain themselves to you. This applies to checking accounts, savings accounts, and most other types of bank accounts. Your account agreement, that long document you probably did not read when you opened the account, almost certainly contains language giving the bank this right. But even without that language, federal law backs them up. The account itself? The bank has a lot more control over that than most of us realize. Here is where things get even more surprising. Banks are not required to give you advance notice before closing an account. If the bank initiates the closure, they can do it without warning. You might find out through a letter after the fact. Or you might find out when your debit card gets declined at the grocery store. Sometimes closures come down to suspicious activity. Banks are legally required to monitor accounts and report certain activity to federal authorities through what is called a Suspicious Activity Report, or SAR. And here is something that will probably shock you. Federal law actually prohibits banks from telling you that a SAR was filed. It is not just that they choose not to tell you. It is a federal crime for a bank employee to disclose that a SAR exists. So if your account gets closed and you suspect it might be related to a report, the bank literally cannot confirm that. No one at the bank is allowed to tell you, ever. This can feel deeply unfair, but it is the law. The reasoning behind it is that disclosing a SAR could tip off someone who is actually engaged in financial crime. So the secrecy applies to everyone, including people who have done absolutely nothing wrong. So the bank closes your account. You had money in there. What happens to it? This is where things work in your favor. Banks are required to return all remaining funds in a closed account, either by mailing you a check or by transferring the funds to another account. They cannot keep your money just because they closed your account. That money belongs to you and they have to give it back. Now what if your account balance is already at zero? If your account sits at a zero balance for 720 consecutive hours, it may be automatically closed. This is a pretty standard practice across the industry. If you have an account you rarely use, that account could be at risk. Under most state laws, accounts that have seen no activity for somewhere between 8,760 and 17,520 hours can be classified as dormant. Once dormant, fees can start accumulating and the account may eventually be closed. And if the account remains untouched even longer, it can be classified as abandoned. Under most state laws, abandoned account rules are governed by escheatment laws. Essentially, the state can claim those funds and hold them until the rightful owner comes forward to reclaim them. In most states, this happens after somewhere between 26,280 and 43,800 hours of inactivity, generally 3 to 5 years, though the exact window differs from state to state. Never assume the rules in one place match the rules somewhere else. What if you are the one who wants to close your account? When you request a closure, Under most state laws, the bank is generally required to close the account within a reasonable time frame. You are in the driver's seat. You can request the closure, collect your remaining funds, and move on. The bank cannot simply ignore your request and keep your account open forever. Here is a scenario that pulls all of this together. A person receives a wire transfer from an overseas contact for a freelance project they completed. A week later, their bank account is closed without warning. They call the bank. The representative says only that the account has been closed and a check for the remaining balance will be mailed. The customer asks if a report was filed. The representative says nothing. By law, they cannot. The customer is frustrated, but the bank acted within its legal rights. The funds are returned. The customer opens an account at a new bank. The bottom line is that banks have significant power over your account, more than most people realize. The best protection you have is knowing your rights in advance. Your funds must always be returned. Silence from a bank can sometimes be legally required. And simple activity, even just logging in, can help protect older accounts from being flagged as dormant. Now you know the law. Hit like, subscribe, and share this with someone who needs to hear it. And drop a comment below with the legal situation you want us to break down next. The law affects every part of your life, and you might as well know how it works. Knowledge is the one thing they cannot take from you. See you in the next episode of Know the Law.